Hi. Are you guys ready? I'm going to give it, I'm going to talk quietly and see. Okay, good. Here we go. You can hear me. Um, hi. Hi, everybody. I hope everybody's morning has been great. My name is Rebecca Kelly Slaughter, and I have the honor of serving as a commissioner on the Federal Trade Commission, and the even greater honor of being here today to speak to all of you. I want to thank the folks at Silicon Flatirons for inviting me, and to all of you for being here for this important conference. I will make a note that I grew up in New York City, and so the term Flatiron to me is associated exclusively with the building on 34th Street. And when I came and looked at those mountains, I mean, it is literally breathtaking. What an amazing place to be, to get to do such exciting work with such an excellent view. So I'm really excited to be here to talk about the near future of US privacy law. I was sworn in as a federal trade commissioner a little over a year ago with basically all four of my fellow commissioners. It is the first time in the over 100-year history of the FTC that we had a full slate of new commissioners all at once, which is a lot, but also a really exciting opportunity. And it is a particularly exciting opportunity to be at the FTC right now because of the moment that we are in as a society. Basically, every day when you open the newspaper, you read about a data breach or some tech company practice that imperils consumer privacy or a merger between companies that control enormous amounts of consumer data. What the steady drumbeat of news shows us is that what we at the FTC already know to be true, which is that we have an incredibly weighty responsibility to meet this moment. So what I want to use my time today to talk about is how I think about our obligation to live up to that responsibility, and how I see it not only as a responsibility, but also as an opportunity. It's a moment of real opportunity for us. So I'm going to try to do that along the following format. I'm going to share a few observations I have developed in the course of my short tenure at the FTC that inform how I think about both policymaking and enforcement. The first is that I think we need to be thinking beyond a narrow concept of privacy to a broader concept of data abuse. The second is that I think it is time to move past notice and consent as the only governing framework for thinking about data. And the third is that it is really important that we acknowledge that data abuse falls disproportionately on vulnerable populations, and we use that observation to inform how we think about policymaking and enforcement. So I'll talk about those things, and then I will turn to, okay, so what do we do? What do we do about it? What tools does the FTC have right now? What are the gaps, and what can Congress do about it? And how do we make the most of the authority that we have today? And hopefully, I will do all of that in an efficient enough way to leave a little bit of time for your questions, but no guarantees on that. Sometimes I get chatty. So let's start with observations. The first thing I said I was going to talk about is that I think we need to move beyond privacy. The term privacy to most people, although I think not necessarily everybody in this room, refers generally to the sharing of information that people would rather keep private. It has to do with collecting data about people. But we can't separate the problems that arise from the collection of data about people with the related problems of the targeting of information to individuals or other decisions made for individuals. I'm going to give you an example from my own life. So I have 3 kids. My oldest is 7. He's really into jigsaw puzzles, which I'm totally all about. I'm very excited about his interest in jigsaw puzzles. Doing a traditional analog jigsaw puzzle in our house is sort of a high-risk endeavor because he has a very helpful 5-year-old sister who wants to jam pieces in, and we have a roving toddler who is as likely to eat the pieces and steal them as she is to contribute productively to puzzle solving. So I thought, great, I will get Teddy a jigsaw puzzle app so he can do a digital puzzle away from the interference of his sisters. And I went on the App Store. There were 2 options for good-looking, reasonably well-rated jigsaw puzzle apps. One was free, and the other you had to pay for. I am cheap, so I downloaded the free one, and I set him off to solve. Not too much later, my husband came to find me and said, "What did you just put on our son's device?" And I said, "Oh, it was a jigsaw puzzle app. Why?" And he said, "I was sitting there and I overheard Teddy listening to this propaganda about the perils of women working outside the home, which he reasonably assumed was not my intentional contribution. And he went over to Teddy and said, Teddy, what are you doing? Like, what is happening here? And we do not leave our children sort of unsupervised with technology. And he said, well, Dad, if I run out of hints on my puzzle app, or if I need to get new puzzles, I just have to watch these videos, and then I can get more hints or more puzzles. That's how I move through the game. Needless to say, we deleted that app pretty quickly, and we replaced it with the paid version that wasn't ad-supported. That's fine. That's easy enough for us to do. But not everybody has the resources to do all of that. And that is a problem that has literally nothing to do with notice and consent. It has nothing to do with other things that we think about it is a problem that notice and consent can't solve. Let me talk now about my second observation, which is that there are other problems with notice and consent. A lot of the authority we use under the FTC Act today is grounded in the principles of notice and consent. It's a reasonable application of a basic consumer protection framework. Tell consumers what you're doing with their data, secure their consent, and keep your promises. This seems very intuitive. But for notice and consent to be effective, each element actually must be meaningful. Notice must give consumers information they need and can understand, and consumers must actually have a choice about whether to consent. And when it comes to our digital lives today, neither notice nor consent feel particularly meaningful. Let me elaborate on that a little bit. I don't think notice is really working. Notice is mostly in the form of click-through contracts. It is literally not possible to read all of the contracts that you click through on an annual basis. And I'm sure everybody's seen the studies that say it would take 76 working days to actually read all of them. But in a year, every year. But let's assume that you really wanted to put your mind to it and read it. Can you actually understand what it is that they're doing with your data? Here's what I will tell you. I am an attorney with some experience in data protection and privacy. I've read these contracts. I have no idea what half of them mean. And I really try to understand. And if I am in a position where I find it difficult to understand, I would imagine that the average consumer who doesn't have the educational background and professional background in this that I have has an even greater problem. Okay, so notice doesn't work. What about choice? Choice is mostly illusory. In these click-through contracts, consumers don't actually have any bargaining power. You can't go to the service and say, well, I'm comfortable with this contract except for this one provision. If you could strike that, I'll click accept. That doesn't happen. You also often don't have a choice to turn to a different, more privacy protective or otherwise more favorable service because there often aren't any alternatives. And this is where I think about it with my competition hat as well as my consumer protection hat. We have a real meaningful competition problem. And finally, I think we have to be very sensitive to the way a lot of these contracts and things that have the patina of choice actually are designed in a way to manipulate consumers into making choices that aren't necessarily exactly what they want, whether it's through dark patterns or the way opt-ins are decided. So as a result, we often must cede all control over our data to use services that are critical to our everyday lives. GDPR, to me, is a really powerful example of this. As everybody in this room, I'm sure, experienced, right after GDPR went into effect, there was an onslaught of accept cookies, click-through contracts. It came from a laudable goal, that consumers have more control about what they are doing and whether they can share their data or not. But what was the result of that huge parade of click-through contracts? Many people just became numb to the question, and the opt-in became a friction that consumers ignore. And I think that that's a really powerful example of how something that is a really good idea in practice, in theory, in practice doesn't work the way we intend it to. It's also an opportunity to learn an important lesson for us. So what should we do instead of just relying on notice and consent? Because it's fine to decry it, but it would be helpful to have ideas about alternatives. So one of the biggest problems that I have with notice and consent is it puts all of the burden on consumers to protect their privacy, even as they have very little control over their data. That's because companies are tracking consumers across devices, across locations, and is shared sort of in the invisible backhaul of data through data brokers and companies with whom consumers actually have no interaction. So in the first instance, I think that companies that have control over data should have the burden of properly protecting it. It shouldn't just be on consumers to keep companies from accessing the data in the first place. As a general rule, we should be considering reasonable consumer expectations about data collection as the guidepost. The Flashlight app is my favorite example of this. If I sign up for a map app, I know it's going to need my location. When I get a Flashlight app, I don't think there's a reason the Flashlight app needs my location. So when we found out that our Flashlight app was actually tracking our location and selling that data, that is a problem. That is thinking about how consumer expectations align with what data is actually used and collected. In addition, I think there is a place for thoughtful purpose and use limitations to protect consumers, especially when it comes to sensitive data like biometrics and location information. And I do think there is a place for clear, prominent, plain English notice and true consumer consent. But again, even in those instances, the responsibility to carefully protect the data should fall to the companies that collect, use, and share it, and not to the consumers themselves. Okay, this brings me to my third observation. Our laws and their enforcement must reflect our democratic values and principles of equality, and therefore protect everybody. We have an obligation to study and acknowledge the ways certain harms fall disproportionately on disadvantaged or vulnerable populations: children, lower income consumers, people of color, the LGBT community, immigrants, veterans. This is something that makes me feel especially proud to be at the FTC, because it's something that the FTC takes very seriously, thinking a lot about how practices may disproportionately affect those consumers who are least able to protect themselves, and trying to target our enforcement and our work to provide some of that protection. It's a principle for the agency. It's a deeply important principle for me too. In 2016, the agency published a report that focused in part on the negative effects data collection can have on lower income and underserved populations. And in the years that have followed, these negative effects have only grown. Here are some examples. Discriminatory algorithms that foreclose important life opportunities such as jobs and loans. There were a couple of stories a few years ago about Resume Bank that actually tended to be weeding out women rather than neutrally looking at resumes. Or we have heard examples of consumers being denied opportunities for credit, not because of their own personal credit history, but because of the credit experiences of other people with similar demographic characteristics or who shopped at similar stores. Vulnerable consumers can be targeted for fraud or predatory payday lending based on their personal data. Data breaches can have an outsized effect on lower income individuals, not because they're more likely to be the subject of a data breach, but because the harms that follow downstream disproportionately affect them: credit damage, abusive collection efforts, depletion of funds, and often they have fewer resources available to correct the problem. And finally, in the story that I referenced earlier, collecting data and targeting manipulative information towards children is a real material problem. So what should we be doing to mitigate these disproportionate effects? The first thing I think we need to do is strategically be thinking about how we deploy our enforcement resources, and I'll talk a little bit more about this at the end. Secondly, I think the US could benefit from improved ability to access and correct personal data errors. We have the opportunity under our law to do this mostly cabin to credit reports, and anyone who's tried to do it knows that it is not such an easy process. It's really cumbersome, doesn't always work. It should be improved in the first instance, and then expanded across more areas of data. And finally, I think we need more visibility into and accountability for the decisions made through artificial intelligence. There's some legislation out there now that talks about a right to an explanation for how AI decisions are made. I think that's important. I think companies that are making decisions through AI also should have the burden or should have liability if those decisions are made in a discriminatory way. Okay, and then the third thing that I think we need to think about is behavioral advertising. and we need to take a serious look at whether the purported benefits of unlimited or unregulated behavioral advertising are worth the cost. The good story about behavioral advertising is that it delivers content to individuals that they are more likely to want to see. One of the concerns I have about that is that it actually facilitates discrimination between individuals in a largely invisible way. So I know what content I'm seeing, but I don't know what content you're seeing. So I can't, unlike a billboard where we know if there's a billboard that is a problem, everybody sees the same billboard. I don't know what Facebook ads everybody else is seeing. The benefits of behavioral advertising are, as I said, first, tailored content for users, and second, the idea that it provides more value to advertisers, which leads to more innovative ad-supported content. I have some skepticism about both of those purported benefits. Tailored content. Okay, maybe I love seeing the ad for the color block swimsuit that is ubiquitous on my social media feed. Also the machine washable shoes, right? Like these things come up, that is content that is well tailored to me. Maybe that's useful, but is it worth it in the context of thinking about white nationalism, recruitment targeted at teens watching video game content? I don't know. That's a challenging social trade-off, and both of those things have been documented. And then when you talk about the value in terms of value to advertisers and content creation, the evidence about the relative value of behavioral versus contextual advertising is a little bit mixed. There was a study out of the Stigler Center last year, estimated the net increase in value for behavioral advertising at only 4%. There are other studies that show a much higher value. I think the jury's still out. And then I hear frequently the assertion that behavioral ads enable higher quality content, but I have not really seen evidence to back that particular claim up. And if you have spent any time on YouTube, for example, you might share my view that the quality of the content on there that is ad-supported is not especially high to begin with. So the big question on behavioral advertising, is there a way to capture the benefits while mitigating the costs? And this is one where, as much as I think it's important to offer solutions when you raise questions, I'm not sure what the answer to this is. But I do think it's worth considering whether there are reasonable limitations that can be placed on how and by whom data is collected and advertisements are targeted. Okay, so those are my observations. What do we do about it? What do we do now? What do we do today? Today, the FTC's data protection practices are mostly under our Unfair and Deceptive Acts and Practices Authority under the FTC Act. We also enforce some sector-specific statutes, FCRA, COPPA, safeguards. And under these tools, the FTC has brought over 200 data privacy and security cases. But the authority has some limits. We have limited remedies. As a general matter, unless there's a rule violation or a repeat offense, we can't get money, what I think of as money damages, civil penalties. We have to pursue consumer injury or disgorgement. Those are harder cases to make under the law, and recent court decisions have made that even harder. The FTC, unlike most federal agencies, does not, on the consumer protection side, enjoy the same kind of general APA rulemaking authority that our colleagues in other agencies have. We are mostly stuck with Magnuson-Moss, which I'll talk about a little bit, but is basically the cranky neighbor of APA rulemaking. It's a lot more burdensome. You got to go through a lot more steps. We have jurisdictional limitations. We can't reach common carriers. We can't reach nonprofits. And then we don't have that much money. A statistic that I cite all the time is that the FTC had 50% more employees at the beginning of the Reagan administration than it does today. At the beginning of the Reagan administration, we weren't doing a lot of data protection work. Our mandate has grown, our resources have shrunk. That is a problem. The FTC, because of these limitations, the majority of the FTC commissioners have urged Congress to pass federal privacy legislation, specifically that gives us the authority to seek civil penalties for privacy violations in the first instance, gives us APA rulemaking authority, and repeals common carrier and nonprofit exemptions under the FTC Act. But I worked in Congress for a decade. I think there are really good, smart people working on this effort, well supported by a lot of outside groups. I think the necessary conditions are there to get federal privacy legislation. but it hasn't happened yet. And I know from experience that thoughtful legislation takes a very long time. So I don't think we can sit around and hold our breath and do nothing. We have an obligation, as I said earlier, at the FTC to do everything we can to meet this moment. So the first way I think we need to do that is be as strategic and aggressive as possible in our current approach to case resolution under the law. And second, I think we need to consider, notwithstanding the limitations of MAG-MOS, initiating a rule proceeding now to address data abuses. On enforcement, what do I mean specifically when I say be strategic and aggressive? I mean, first, we should prioritize cases where the harm falls disproportionately on vulnerable consumers. That means bringing COPPA cases. That means looking, and we do this, I don't mean to say that the agency doesn't do this, looking at cases where military consumers are targeted or other vulnerable populations. Second, I think we need to be really careful to pursue relief that meaningfully changes the incentives for future data abuses. I've been really proud to support resolutions in a lot of data protection cases that have come before me in my time at the agency, but there have been a couple of cases where I thought we really didn't push as far as we needed to go to change the behavior of the companies. And the two that most obviously come to mind were our resolutions in Facebook and YouTube, which was just announced this week. I am as sensitive as anybody to the limitations of our authority and our resources. I think we can both work harder with what we have now and ask for more. I don't think those things are mutually exclusive. And I also think we need to be one of the ways we can do that is investigate and assess individual accountability in the cases that we pursue. This is not a question of vindictiveness. I don't think we should go after executives just for the principle of doing it. I do think that holding executives accountable for the decision-making incentivizes executives to care about the decision-making that happens at their companies. And Sarbanes-Oxley, to me, provides a really powerful example of this. Sarbanes-Oxley put responsibility squarely on executives for making sure that the accounting of public companies was on the level. And we haven't seen the kinds of violations that led to Sarbanes-Oxley since then. And I think that's a good model that we should be thinking about. And finally, I think we need to litigate cases when it's necessary. When we can't negotiate relief that we really think will solve the problem, we need to just sue and try to pursue relief, because I think litigation has a value above the remedy that you could receive at the end of the day in terms of transparency and public accountability and potentially a finding of liability at the end of the day. Finally, my last point is going to be on rulemaking. As I mentioned earlier, in the 1970s, Congress removed the FTC's general ability to issue consumer protection rules under the APA, and instead it saddled us with the Magnuson-Moss Act. Rulemaking initiatives under MAG-MOS are slow, challenging, and resource-intensive, but we should consider them anyway. I referred earlier to MAG-MOS as the cranky neighbor, and I think the reputation for crankiness is well-deserved. You have to do advance notice, you have to have congressional heads up, you have to do public hearings, and doing that takes time away from other efforts, including enforcement. In addition, if we initiated a MAG-MOS rulemaking on data protection and Congress proceeded with legislation, all of that effort could be mooted by future congressional action. So those are real challenges, but I don't think that well-deserved crankiness reputation should keep us off the lawn, as it were. I think that the effort can still be valuable. The process of MAG-MOS rulemaking generates useful public commentary and dialogue that could inform legislative debates and enforcement decisions. And the worst case scenario isn't that we start rulemaking and then Congress acts and there's a new law. The worst case scenario is that Congress doesn't act and we haven't done anything either. And I think that's something we need to be really mindful of. So with that, I will wrap up, and I know everybody is waiting for lunch, so I don't want to take too much time, but if you guys think it's okay, I'm happy to take a couple of questions. Yes, okay, couple of questions. If you have any. If you don't, it's totally fine.
Hi, I was curious, you mentioned that the Reagan administration, since then, the FTC has lost 50% of their resources. If you did have the additional resources, how would you allocate them or deploy them?
So, great question. And to be clear, we have 50% fewer employees. It's not exactly the same as dollar resources, but where would I put more employees? I would put way more employees on data privacy issues. I would put more employees on enforcement. I would put more employees following up on the orders that we have to make sure that companies are really living up to their obligations. I would have a Bureau of Technology at the FTC. I think we have a Bureau of Economics, and we use an economist input on every single case that we bring. I can't think of any case, maybe there was one like cement transport merger, that doesn't involve a significant technological element where we wouldn't benefit from the experience of a dedicated technologist. So those are some of the things I think that we could do. I also think more resources could free us up to litigate more on the cases where we didn't think we were getting what we needed in settlement. Right now, litigation isn't just is it worth it to litigate on this case, but if we litigate on this case, what cases are we not bringing instead of this one? And those are really hard decisions. Other questions? Why don't we go here and then in the back? I'll let you guys, yeah.
Considering your comment just right about the technology involved, and that technology is generally software, and putting aside the fact that you don't have a lot of power of rulemaking, but I'm just wondering if anyone has ever considered kind of leveraging the concept of open source software by requiring source code for some of these technologies to have transparency over what's going on. Because if companies like, say, I don't know, Volkswagen comes to mind, had to provide their source code, they might have been a lot more reticent to, do something nefarious.
So there are two ways to think about imposing requirements. One is in the resolution of a case, and the other is in rulemaking. I'm all for thinking broadly and creatively about all things, and certainly in case resolution, I don't think we should limit ourselves to the kinds of remedies that we have always traditionally used. I think, if you find the source of the problem and it's the proprietary keeping secret of source code, then a good, well-matched remedy is certainly something that's appealing to me. But you just have to remember that in a settlement negotiation, you can only do what a company will agree to do, and usually companies are not willing to do things that really change their fundamental business model. So these are tough questions, but I like the idea a lot. Yeah, go ahead.
We've heard today regulation and protection for privacy serving as a potential barrier to entry or stifling of innovation. I was curious if there's ever a conversation about a barrier to entry that could result from a monopolization of data by a few large companies in, say, the field of machine learning or something like that.
Yeah, that's a great question, and we're going to make this the last question so everybody gets to eat. My colleague Noah Phillips has spoken, who's one of the Republicans on the FTC, has spoken very eloquently about his concerns that privacy regulation could inhibit innovation and serve as a barrier to entry. I am with him that is something to which we need to be sensitive. I depart from him on the grounds that means we shouldn't do it. Like, we should do it right, and we should do it carefully. It is absolutely the same concern. I have the same concern that when we look at monopoly problems, control over and foreclosure of opportunities to access data is something that we need to be taking a really, really hard look at. And I think thinking about nascent competition is something in particular, and that's where this really comes up in a lot of places, is something that the FTC, the Republicans, and the Bureau leadership have said publicly that we're taking really seriously and want to take a really hard look at. And I'm all on board with that. Okay, thank you guys.